A gag order. 6 swatting calls against one family. A judge who was himself the target of an alleged doxing hoax investigated by the FBI. If you were building a law school hypothetical for when a trial should move counties, you couldn't invent a better fact pattern than the Karmelo Anthony case. And yet, the trial never left Collin County. So, what does this tell us about what to expect in the trials of Tyler Robinson for the murder of Charlie Kirk and in the Luigi Mangione case for his murder of a healthcare executive? I'm going to break that down. Hi, I'm Melba Pearson, also known as the Resident Legal Diva, and this is The Breakdown. Make sure to like, comment, and subscribe for all things at the intersection of law and politics, and be sure to follow me at Resident Legal Diva on YouTube and Substack, where you can get deeper breakdowns of me going into these issues and how they impact everyday life. I'm using the Karmelo Anthony case as a teaching opportunity because her trial basically just finished, and using that sort of as the coming attractions for what we're going to see in some very high-profile political trials coming up. On April 2nd, 2025, 17-year-old Austin Metcalf was fatally stabbed by 19-year-old Karmelo Anthony during a rain delay at a Frisco, Texas track meet after a dispute over a space under the team tent. So the case exploded online within days with misinformation, doxing, and a national argument about race, bail, and self-defense law. By July 2025, the presiding judge already issued a gag order which barred the attorneys, witnesses, and court staff from making any public comment. By the time the trial started in June of 2026, so we're talking a year later, the court had layered on a full decorum order. So no cameras, no live streaming, limited media seats, restriction on courthouse protests, all of that. Both of the families involved reported being targeted with swatting calls, which, for those who aren't familiar, basically somebody anonymously calls the police saying, oh my gosh, there's somebody being held captive, whatever, something that would trigger the SWAT team to respond. And then, of course, a traumatizing situation unfolds because you in your house and next thing you know, SWAT's breaking down your door, right? So that's a thing, not cool. All right. The trial itself was held in Collin County Courthouse in McKinney, Texas, which is the same county where the stabbing happened. Why didn't this become a change of venue case? So, here's the standard. Under Texas law, a defendant can ask to move a trial when there is so great a prejudice in the county that a fair trial isn't possible there. And that is a really high bar, and deliberately so, because courts don't grant venue changes just because a case is famous, controversial, or covered heavily by local news, right? We saw that in the Diddy case, right? Everybody knew who Diddy was. The case was tried in Manhattan, where he lived and spent, a ton of time, right? That case didn't get moved. Same thing here. Now, judges generally have a strong preference for curing publicity problems in place rather than just relocating the whole trial. The tools that they use, which is sort of like that first line of defense: extensive jury questionnaires, a large initial jury pool, individual voir dire, which is basically individual questioning on media exposure, and a gag order to stop new prejudicial statements from entering the news cycle while the case is going on. So, in Anthony's case, they had about 500 prospective jurors who were screened and questioned before they settled on the 12 jurors and 6 alternates. The scale of the screening is itself the court's substitute for a venue change, right? So again, quick explainer, and I did one previously on jury selection, but always bears repeating, right? You get your summons. You come into court, you sit in a big room, right? As each judge who is having a trial that day gets ready, they call down and say, hey, send up 40. Hey, send up 60. Hey, send up 100, right? And then every juror has to fill out a questionnaire. Sometimes what you say in the questionnaire is enough to eliminate you. If it's not, then both sides and the judge asks questions of you as the wider group. If you say something that may be questionable for any of the parties. They may pull you aside individually to ask you one-on-one questions, right? And again, if they saw something in a questionnaire that they're like, we want to know more, they again will pull you aside for an individual one-on-one questioning. That's generally how this works. But in these types of high-profile cases, a questionnaire that might be, 3, 4, 5 pages may turn into 10 pages, right? Instead of, let me get 40 or 60, you have, let me get 500, right? Because as you go through and you end up striking people for a variety of reasons, rather than every 2 seconds calling to get more, you just have a ton of people right there. And as you eliminate, you just keep going, keep going, keep going. It doesn't hold things up, right? So the fact that the judge pulled down that huge of a panel of potential jurors, that tells you that's his way of trying to deal with the fact that the case wasn't moved. Here's the other part that surprises people. Even if a venue change motion had been filed and won, it likely wouldn't have solved the actual problem. So prejudice for venue purposes is about local news saturation, making an impartial jury impossible to find in that specific county. But here's the thing. This case wasn't a local newspaper story. It was national. And the algorithms was going nuts. It was big on TikTok. It was big on X. So this went national before the local outlets even had a chance to get to their computers, right? So moving the trial, let's say to Houston, Texas, or Lubbock, doesn't outrun a story that everybody already saw on their phone. So change of venue doctrine was built for an era of local newspapers and local television. We're now in an era where everything goes viral in a heartbeat. So maybe time to kind of update what that looks like. There's basically nowhere left to move a trial to if everybody already knows about it. What does this mean for Luigi Mangione and Tyler Robinson? Well, this is the doctrine that's playing out live right before our eyes in real time. And what's interesting here is that they show opposite sides of the same problem. He's been charged in the murder of Charlie Kirk at Utah Valley University, and he's right in the middle of the same exact fight Karmelo Anthony's case never had. So Tyler Robinson's defense has already gone to the Utah Supreme Court twice, once over cameras in the courtroom and once over hearsay evidence, arguing that the saturation coverage makes a fair jury impossible. Tyler Robinson's own team put on an expert that said he found that 99% of Utah County residents recognize the case. And 64% already believe he's guilty based on the media coverage alone. A judge Judge Graff, even had to hold the prosecutor's office in contempt for public comments that way crossed the line. But the remedy the court in the Tyler Robinson case chose wasn't relocation. It's literally the same toolkit we saw in the Karmelo Anthony case: an expanded jury pool, revised jury questionnaires, a decorum order. And that's the doctrine working exactly as designed. And it still leaves the defense arguing that no fix is enough short of moving the trial. And that's a request that Utah's courts have consistently declined to grant. Now, Luigi Mangione case flips the entire script. Change of venue law assumes local sentiment runs against the defendant. Well, in Mangione's case, prosecutors have argued almost the opposite problem. The federal trial has been pushed back in part because of concern that a highly publicized state trial and a wave of public sympathy for Mangione himself could shape the jury pool in his favor. So a federal prosecutor told the court on the record to look out the window at all the supporters who believe Mangione did right. So there's a whole bunch of people outside the courtroom being like, free Luigi. That already tells you where the mindset is. No one is asking to move that trial out of Manhattan because, for once, The person worried about local prejudice is the government, not the defense. So where are they going to put it? It's the same doctrine, the same publicity-driven anxiety about getting an impartial jury, just running in the opposite direction. This is the paradox that you're dealing with. The more viral a case gets, the less a change of venue actually accomplishes. And the more courts fall back on tools like gag orders, juror questionnaires, and sequestration instead. Now, sequestration is when you basically lock up the jury for the entire amount of time of the trial and the time that they're deliberating, take their phone, everything else. They can't watch any coverage, that sort of thing. So that way they're in a bubble and only focused on what's going on in the courtroom and then deliberating accordingly. That comes with its whole other set of issues because, you're basically cutting people off from all outside contact, and that becomes an issue in and of itself. But I'll discuss that at another point in time if that comes into play here. What we're looking at here, 3 different cases, 3 different verdicts on whether a courtroom can ever truly be neutral ground. Sound off in the comments. What surprised you about learning about change of venue? What updates do you think the law can even make to catch up with how viral cases go now as opposed to how they did in the past? I'm really curious to hear your comments on this one. I'm Melba Pearson, also known as the Resident Legal Diva. Stay safe, stay informed, and keep demanding justice. Take care.